Friends, in continuum of our playlist wherein we are discussing patentability of new emerging technology based inventions, we bring this video in which we are going to consider a real life example. In this example, an application for grant of patent was filed by IIT Madras, which the controller gave its decision as non-patentable. There were primarily two questions which drove the controller's decision. Both these questions were interrelated. Very first was that whether such an invention for which the application was filed be patented even if this invention was using modern technologies such as machine learning, data analytics, etc. And the other interrelated question was that will the patent office would consider it as a technical invention or reject it under section 3K. This video would be most beneficial for patent professionals, patent agent exam aspirants, inventors who are working on these new technologies, or somebody who is wanting to have a real grasp on CRI guidelines, primarily because of three reasons. Because this decision clearly demonstrates, firstly, how the Indian Patent Office applies section 3K, how the inventive step objections are analyzed, and most importantly, why do many AI and software based inventions fail despite them do those inventions using sophisticated mathematics and business logic. So let us give you some background of the case. This application was related to the invention titled A Method and System for Determining Optimal Pricing of Risk Premium for a Data-Driven Insurance Product. Now here in this title, these two sequence of the words stand out. Firstly was determining optimal pricing of risk, and second is the data-driven insurance product. Now to this invention, to determine optimal insurance pricing, made use of modern technologies such as data analytics, predictive modeling, algorithm processing, etc. and also use concepts which were more economics related, such as hurdle rate optimization, determining of loss ratio, putting out the demand elasticity in respect to determining of the price, profitability prediction. So this invention basically cascaded both the modern technology concepts and economical concepts to bring in this invention and file the claim for patentability. Now at this first glance, this invention would appear highly advanced and sophisticated. But as the decision of the IPO would show, which we are going to analyze further in this video, that sophistication or advancement does not automatically make an invention patentable. So now let us delve deeper into the background for the controller's decision. Now the controller, in the process of analyzing or examining the application, cited some prior arts which disclosed risk-based pricing, profitability calculations, insurance premium optimization, and loss ratio analysis. Now if you carefully try to study all these disclosures which have been made through the prior art, you would notice some striking resemblance between these disclosures and the concepts along with the economical aspects which have been used in this invention. The applicant, countering these disclosures, argued that its invention introduced some unique elements such as elasticity model of demand, hurdle rate optimization, and optimized loss ratio determination. Basically, the focus of the applicant was that all these disclosures, this invention was unique in the aspect that it optimized whatever was disclosed in the earlier applications. Now with reference to the applicant arguments, the controller further observed that when these teachings are combined with existing knowledge in the field, the claimed invention would become obvious to a person skilled in the art. Meaning thereby the controller argued that if a person on the skilled in the art tends to go through these prior art, then there is a good probability that he would reach out to what the invention has been claiming and concluded therefore that this invention would be obvious to persons skilled in the art. So hence, as per the controller, this would fail the first test of patentability, which is the test for non-obviousness. And accordingly, it cited that the invention fails the non-obviousness criteria under section 21JA of the Patents Act. Now, if you would recall that in the playlist we had cited that three tests were very important to judge the patentability of an invention. Firstly is the non-obviousness criteria. The second is the inventiveness aspect of the invention, and third is the technical effect, which basically translates into patentability examination under section 3K. So the controller concluded that the invention fails the non-obviousness criteria of the Patents Act. The controller further analyzed the claims and observed that the invention essentially involved these sequential steps. Now, as you would have possibly learned going through our earlier playlist, that one of the methodology as predicted through the CRI guidelines was breaking the claims into sequence of steps and then determining what the exact substance of the claim is. So it determined, the controller breaking the claim into sequence of steps determined that this invention basically translated into collecting insurance related data, analyzing risk parameters, performing mathematical optimization, then calculating premiums through that. Based on this calculation, predicting profitability and then giving out the output. Further, the controller concluded that the invention was executed only using generic computing infrastructure in which standard processors, memory, display or communication ports was used, meaning thereby that no novel hardware or no modified hardware was required for implementation or for working out this invention. So hence, the controller concluded that there was no specific hardware innovation. The claim merely implemented financial and mathematical logic on conventional computer systems, and therefore the invention did not exhibit any inventive step. So hence, after the non-obviousness test, the invention did not stand the scrutiny under the second test for patentability, which was the inventiveness, and hence the controller concluded further that the invention fails the test of inventiveness under section 21JA. So till now, going through what the controller has observed, we can draw some important lessons which would be beneficial both for the inventor who are working on such inventions as well as for the patent agent examinations paper 2. So many candidates would erroneously assume that if the feature is mathematically complex, it automatically becomes inventive. But the learning is that the patent law does not reward complexity alone. The invention must demonstrate three things. Firstly, there should be a technical advancement, technical effect, and non-obviousness. It should be non-obvious to the person skilled in the art. Merely using technology-laden words does not make an invention inventive. Now, going into deeper into the examination part, the controller also examined this invention under section 3K. Now, as you would know that under section 3K, the following four categories are excluded from patentability, which is mathematical method, business method, algorithm, computer programs per se. In our previous videos in the playlist, we have elaborated in detail the methodology as have been prescribed under CRI guidelines for each of these specific categories. Now, why the application failed under CRI guidelines? The reason was that one of the most important concepts under CRI jurisprudence is that business improvement is not the same as technical effect. The applicant had argued then the invention improved profitability, premium optimization, and pricing efficiency. But the controller, after analyzing the sequence of steps, concluded that these all these aspects were business outcomes, not technical effects. The controller specifically observed that the invention did not improve any of the technological features such as computer functioning, system architecture, processing speed, network performance, or even hardware capability was the standardized requirement. There wasn't any requirement for novel or inventive hardware. And therefore, the controller concluded that the invention remained a mathematical and business method implemented on generic hardware. And obviously, in this case, this would make the invention non-patentable under Section 3K. So hence, the third test of patentability also does not get satisfied, and the invention gets excluded from patentability under Section 3K. So, the learnings. Merely adding technology-laden words such as modern technological word nomenclatures, AI optimization, predictive model, machine learning, neural network does not make an invention patentable. A tangible exhibition of a real technical effect is a necessary prerequisite for consideration of patentability of invention, meaning thereby the invention must demonstrate technical effects such as how the invention improves technology itself, does it helps in improving computer efficiency, or improvement in system architecture make it more less requirement on any of the hardware features, how the hardware interacts differently, or how the technical resources are optimized. Here we are talking about the technical. There should be a tangible technical effect in terms of saving on the technical resources, not exactly the economical resources which the invention seem to be focused on. In the absence of technical effects such as above, even sophisticated inventions will fail the patentability test. So, finally concluding, we can safely come to conclude that sophisticated mathematics alone is not enough, business optimization alone is not enough, AI terminology alone is not enough. To survive Section 3K, the invention must demonstrate both the technical effect and also make a technical contribution to the state of art. And this is exactly where most emerging technology patent applications succeed or fail. So, important takeaways for patent professionals and patent agent exam aspirants. It is very important to develop a deep appreciation of the latest IPO requirements and CRI guidelines, primarily for three reasons. Build claims which will stand scrutiny under Section 3K. And the way to do is that you must have a clear understanding on how the controller will analyze algorithm, business methods, and software implementations. The second is the inventive step analysis. Develop a deep understanding on how multiple prior art documents are combined to tailor the claim, meaning thereby that before filing the application, do a patent prior art research yourself, bring out the expected prior art documents, combine them to draw a cascaded teachings from those prior documents, and then try to anticipate what the controller is going to draw conclusion of, and possibly after analyzing what the anticipated controller learnings would be, then you tailor your claim before the pre-filing stage itself so as to be better prepared to respond to the controller objections or queries. And finally, the biggest takeaway, the CRI drafting requirements must be adhered to. They could make and break the application. Why this is important is that CRI guidelines include the latest IPO requirements and requirements specific to each of these new emerging technologies. So the traditional way of examining examining the older technologies does not suffice the new modern age technologies based inventions. So how could this application would have had the positive result? This could have been a positive result in terms of the controller accepting the application is had they used some novel technical architecture, some hardware interaction they would have done on using the optimization mathematical processing which they had showed there, some processing improvement or some technically resource optimization if they would have showed, then the outcome would have been different. So as we have mentioned here, the three aspects which are of utmost importance for any inventor wanting to file an application for these modern age technologies. The key aspect is that understanding CRI guidelines have become indispensable today. And to meet this exact challenge, we have brought in this book where all these aspects have been discussed in depth. This book is titled Patenting Emerging Technologies from Algorithm to Quantum Inventions. This book does not merely explain the law. It takes in the real life examples to show how to work about patentability challenges in real world scenarios. In this book, we have discussed CRI guidelines, section 3K, on what are the requirements and what are the things which how to frame the claims to circumvent the objections under section 3K, the technical effect requirements, then inventions, modern emerging technologies, AI and ML, machine learning patentability, blockchain inventions, quantum computing inventions. Then real life examples we have taken based on many of these emerging technologies to claim drafting strategies. As we have mentioned earlier, that the traditional way of examining the old technologies does not satisfy the modern technology based inventions. The examiners would examine the modern age technology based inventions under CRI guidelines. So accordingly, you have to draft claims so that they satisfy both the CRI guidelines as well as the IPO guidelines. And for this, we have taken real examples of all these latest emerging technologies and provided you with practical solution which would help you overcome objections. Once you go through them, you will get a necessary confidence to adapt these examples and the solutions provided for your own invention. This book is designed to help inventors, patent professionals and patent agent exam aspirants, especially for paper 2, because it is very much likely that in the new era, questions would be tailored to understand the candidate's understanding of the new CRI guidelines or the latest IPO requirements. So it becomes very much important to understand how to practically navigate patentability challenges, especially in relation to emerging technologies. So you can very well understand that this book will not be an optional reading. It would be a strategic asset for your professional success. This book is available on Amazon. You can search by the title on Google, or the link is provided in the description. So to end this video, we would just say that if you want clarity, confidence and competence in patenting new age technologies, this book belongs to your desk. And also, we would want you to participate with us in our journey of this playlist, wherein we are taking examples, real life examples of inventions based on new technologies, and highlight to you the do's and don'ts, the pitfalls and the red flags which should be taken care of so that you are able to build a better application. It is very important to understand that having a grip on technology alone is not enough. You must also understand how to patent it. Thank you for watching.